Dear viewers, welcome to this episode of Expert Speaks. We have done a lot of videos with respect to inheritance, how somebody can secure their assets in the unfortunate event of death, and how the assets can be smoothly transferred to the legal heirs. We have detailed videos on various topics. Today, I'm going to go back to the basics because you have asked a lot of questions in the comment section asking us to clarify many of the points. So this episode is all about wills, nominations, and trust. Which one should you use? Who should use which one? Stay till the end of the video. We are going to discuss very important points about all these aspects. This is NRI Money Clinic for you, and I am Dr. Chandrakant, your financial guide for a happy living.
NRI Money Clinic. No hype, just the right advice.
Dear viewers, to talk about the wills, trusts, and nominations, the guest faculty today is my eminent faculty member, Mr. Nikhil Varghese. Mr. Nikhil Varghese is not somebody new here. He has been appearing on our channel multiple number of times. He has done a lot of videos. For those people who are watching this episode for the first time or watching him for the first time, let me give a brief introduction of Mr. Nikhil Varghese. He is a chartered accountant by profession. He worked for the Big Four CA firms, and currently he is the co-founder of a startup by name Yellow, which is dedicated for democratization of wills. Prior to this, he has worked for a wealth management firm and heading the South India division for their estate planning related works. Welcome to this episode, Nikhil Varghese.
Thank you, Dr. Bhatt. It's always a pleasure to be part of your sessions and having a conversation with you. And your audience are extremely interactive, and look forward to a very interactive session today as well. Thank you so much.
Nikhil, we have done with you as well as other faculty members all things pertaining to wills, nominations, and trusts. While audience has basic knowledge of what these are, they are in a state of confusion. Which one shall I opt? What are the advantages and disadvantages of each of these? So let's do some knowledge sharing in this video, which will give an idea about what people have to use and understanding these three aspects of wills, nominations, and inheritance. So can we have some basic data to start with?
Absolutely. It's important to understand broad definitions of what these tools of estate planning means, right? Now, let's look at wills, right? Will as a document, it's a legal document, of course. Basically, what the will does is that it specifies who are you, what are your assets, and how these assets needs to be distributed. It's essentially a comprehensive document that covers all your assets, from properties to investments to personal belongings, on how these assets needs to be distributed. That's broadly what a will does. Now, coming to nominations. Nominations are commonly used for mostly financial assets. There are certain jurisdictions, even nomination works even for real estate, but not for all jurisdictions. But commonly for financial assets like bank accounts, fixed deposit, mutual funds, insurance policies, etc. It's in a way a very simple process where you appoint someone, maybe relatives, sometimes friends, to say that what happens to these assets, who should take charge of these assets once you're no. That's the role of a nomination. Now, coming to the last aspect that you spoke about, there are of course many other tools, but if you look at trust as another tool that is commonly everybody asks about, is that trust, again, while it's a estate planning tool, it's a little more evolved legal arrangement. Here, basically, you transfer your assets to be managed by trustees for the benefit of the beneficiaries you choose. Trust can be created, during your lifetime for the benefit of the beneficiaries and continue to be available post your lifetime as well. Basically, it can be a multi-generational structure. Sometimes it can also be set up as part of your will, wherein when you're not around, your will can create a trust for you. These are broad concepts of trust, will, and nomination.
The crucial question is, yes, these are the instruments which are available. But for a person who wants to work around it, how will he decide which one should he use? Should he use all? Should he use a specific one? Is there a choice one over the other? How should somebody go through the selection process?
That's an excellent question, Dr. Bhatt. The truth actually is that it's not always either or situation, right? The reason I'm saying that is that one need to actually look at what are the pros and cons for each of the option and see what is the best choice depending on individual circumstances, family situation, and nature of the assets. Right? If I were to put a broad reference to this, in our minds, no matter what tools that you look at, will become something which is basic that everybody should do. Right? It should be done as of yesterday. The others should be over and above a will. That's the way we look at it.
Let's say somebody wants to decide between these three instruments. Of course, a professional's help will be sought. It has to know about these wills. Can you broadly tell what are the advantages and disadvantages of each of these instruments? Since you have three, obviously they must be having some advantage over some place and some could be more suitable in some other places. Can you simplify it and tell what are the advantages and disadvantages of each one of these?
Absolutely. Like you rightly said, if there are choices, which would mean that there are pros and cons for each of these options, right? Now let's start with will itself, right? For a will, it's obviously, like I said, it's a base document that we look at. The advantage of a will is that it gives you complete control over all your assets on how they need to be distributed. First of all, it's very, very simple document and something that anybody can do at the comfort of their home. Very cost effective. Will can be handwritten. It doesn't even need to be registered. Although registration is something which is advisable in certain cases where there are properties involved or you foresee a potential litigation in the future. So that's broadly the way, the ease or simplicity of the execution is where will comes in handy. Now, what's the downside for a will? The problem with a will is that it's not really a problem. There's a problem with any document in India is that it can get contested. It can be contested in court, which can lead to lengthy legal battles. And also, what happens in a will is that while the assets are in your name, on your device, the transfer of assets will require the beneficiaries to go to each institutions, be it banks, financial, insurance, demat authorities, even sub-registrar for property transfer, because title is in your name, title transfer needs to happen. And therefore, it is still a time-consuming, sometimes even take years before the assets are transferred to the beneficiaries when litigation comes into the picture. Now, trust, on the other hand, offers most control and flexibility with respect to the overall inheritance process or a succession process. They can be used for complex estate planning, protecting assets for minors, those with special needs. In those scenarios, how to plan for it, trust becomes extremely handy because these are things will can't do. It can even offer asset protection, be it from financial risk for businesses that you're in, personal guarantees that you would have given, or even separation risk, right? When marriages go worse, go sour, your assets are part of the separation settlements. How to plan for it, trust becomes very handy. And of course, estate duty protection. India doesn't have estate duty today, but other jurisdictions does have. For NRI community, I think if you're part of jurisdictions where estate duty is there, mind you, assets not only in the country that you are residing in, assets in other countries may be also part of the estate duty requirement. And therefore, planning of trust, etc. becomes very handy. Now, other aspect that we should look at from a trust is that trust also helps avoid, probate process. What do I mean here is that in India, certain jurisdictions like Bombay, Calcutta, Chennai, if you have a will, for Hindus specifically, the will has to be proved in the court of law before it can be given effect to. Because in the trust, assets are already part of the trust. There's no requirement for doing the probate process. Families get immediate access to the asset. Zero delay. Literally speaking, if the person passes away, the next minute, the beneficiaries have access to the assets. That's a benefit of a trust. In a will, of course, it takes some time. However, the negative for a trust would be the whole aspect of setting up a trust is a little more complex compared to a will. And also sometimes it can be a little more expensive as well. And what is more important here is that it's not a structure for everyone. You need to see if your objectives are not fully met through a will. If your objectives are not fully met is when you should explore trust as a tool to look at your estate planning. Now coming to nomination. While nomination technically is not an estate planning tool, the way one would need to look at nomination is that it helps expedite the transfer of assets process. Now by law, what is relevant here is that nominee is just a custodian of the asset or a trustee of the assets, and nominee is not actually the legal owner. And therefore, why am I saying this? Let's take an example, right? So for instance, if you're nominated someone to your bank account, what the banks usually do is that to access the funds soon after the death of the asset owner, all that you need to provide to the bank is that give the death certificate along with the claim forms. Banks easily transfer the asset to the nominee. But the important point here is that while you've got access to the assets, are you the beneficiary? Typically not, because nominee is just the custodian, like I said earlier. Now the role and responsibility of the nominee is that the nominee now needs to distribute this among the legal heir. How is legal heir defined in India? It's only two ways. If you've written a will, then will defines who the nominee is. If you have not written a will, then the Indian succession law, which is religion, gender specific, defines how the asset needs to be distributed. Broad parameters basis that the asset needs to be distributed. We usually assume that nominee will become a legal heir, so nothing needs to be done. That's the reason I said it's not an either or option. option. Even if you do nomination, you should back it up, align the nomination with your will so that it becomes a foolproof mechanism.
Nikhil, you mentioned about this personal inheritance law, which is a little bit complex here. You said that it depends on religion, it depends on the gender. How do the tools that you have mentioned get affected because of this personal inheritance law in India?
Let me talk about the personal law itself, right? That I think that'll give you a clarity. See, in India, inheritance law can be actually quite complex due to diverse religion and cultural landscape that we have. For Hindus, Sikhs, Jains and Buddhists, the Hindu succession law comes into the picture and it applies for them. For the rest, the Indian succession law comes into the picture. Now, these laws are close to 100 years old, not edited, not amended. The last amendment, if I recollect, was substantial amendment, was for Hindu succession law in 2005. Nothing much has been done. And therefore, the ideology with which the laws have been created was the landscape at that point in time. Things have completely changed today, right? Now, why am I saying and what does this mean? These laws prescribe set parameters on how the asset needs to be distributed if you don't write a will. For instance, for a Hindu male, assets are distributed among spouse, mother, and children equally. For a Hindu female, assets are distributed to spouse and children equally. But if, God forbid, both spouse and children are not around, your in-laws may end up getting assets before your own parents. Maybe whether it's right or wrong, it's a different question. Is it your choice? That becomes very important. If that is not your choice, then you're leaving it to law to decide how the asset needs to be distributed. And that's where it becomes important to plan around this.
Nikhil, I understand all these points. And my sincere advice for the viewing audience, as well as somebody who is looking out to plan around this, is to sit with a professional, take their guidance, and take meaningful steps to secure those assets depending on your individual circumstance. Nevertheless, if someone is attracted into doing something around it, what could be the starting points?
Absolutely right. It's important to have clarity in terms of how we approach it, right? For most people, what I look at is that I would suggest starting with a properly well-drafted will. It's relatively, like I said, simple, cost-effective, and covers most needs of most people. And in a broad basis, will should do the job for everyone. Make sure it's clear. These are things that is important, right? Make sure it's clear, unambiguous, preferably register it if you have real estate property in your portfolio. This will help making things much more easier for families when you're not around to claim these assets. Next, I would recommend making nominations for assets like bank accounts, fixed deposits, insurance, and certain investments. More importantly, why I'm saying this, like I said earlier, is to align a nomination with your will so that tomorrow when the nominee goes, they're able to easily access these assets from the banks and financial institutions. They can get access to it. And more importantly, because your will says that you are also the actual beneficiary because you are nominating them as the legal heir. They are also the final owner or ultimate beneficiary for these assets, and nobody can question this further. But if you have substantial assets, minor children, specially abled family members, specific requirements like providing for a family member or providing family member with special needs, or exploring situations where you're running businesses, your good amount of financial risk, asset protection is something which is in your radar, then consider putting together a trust for your estate planning. Obviously, for this, consult with a professional who can help you set up a trust that is relevant to your particular requirement, because it's not one size fits all. It has to be built, custom, tailored for your requirement. The last point that I would like to say here is that, again, I'm re-emphasizing this. These are not mutually exclusive tools, right? You can have a will, make a nomination, and set up a trust if your situation warrants it, right? In my mind, will is a foundation. It has to be done by everyone. Whether you want to do trust, etc., is something that you can decide depending whether all your objectives are whether met or not. But will is something that needs to be done. Financial assets, of course, is a very simple aspect. Get your nominations done. These are very small steps that one need to take, but it can go very, very long way in helping your family recover your assets. Otherwise, it goes on to a large pool of unclaimed assets in India, which is growing. It's painful to hear the numbers. It's 150,000 plus crores. So I think your hard-earned money should not be joining part of that pool.
Dear viewers, we are listening to you. You let us know a lot of things, what you want, what your feelings are, where you need answers through your comment section. We make every effort to answer to as many people as possible. Sometimes because of the sheer numbers which come in, we may not be able to answer each and every one. It doesn't mean that we are not reading your responses. I request all my faculty members. Today, I am requesting Mr. Nikhil Varghese to go through this comment section, listen to what audience has to say. And when we have repetitive questions of similar nature, let's do a video and try and answer our audience. Nevertheless, many of you have requested me to bring a service around wills, trusts, and nominations and other things. So we have heard you. Now NRI Money Clinic has included these services in their suite of services being provided by NRI Money Clinic. We have a team of experts on the ground. If you want any of these things to be done, you can reach to us through a WhatsApp message. Our number is given in the description box below. We have also provided a link there. Just click on the link. It takes you to the WhatsApp. Let us know what is that you are looking for. And it's our responsibility to connect you with the right professional to solve your problem that you have on the hand. Why delay? Send that message right. Nikhil, thank you. Before I let you go, your final thoughts are a couple of tips for our audience.
Absolutely, Dr. But, if I were to give my final thoughts here as a, rather like a pro tip from what we are doing for multiple families, basic sanities that one need to look at. Let's look at it step by step, right? First, remember estate planning isn't just for the wealthy, because this is a popular notion or misconception everybody has. Everybody should have at least a basic will. I think I've spoken enough about that in the episode today, but regardless, it becomes very important. Therefore, basic will something everybody should have, regardless of your financial status. Second, review and update your estate plan regularly, especially after major life events like marriages, birth of a child, or significant changes in the assets. Third, be very, very transparent with your family about your estate plan. This can prevent disputes in the later. And more importantly, if you've put together your time and effort and putting together an estate plan, it's important that they know that something on these lines have been done, so that they don't assume that nothing has been done and let me go the interstate succession route, which is the difficult process that a family faces. And lastly, the fourth point would be, while we have provided general advice in terms of how one could go about. It's obviously not something that I need to emphasize here, but it's given that everyone's situation is not common but very unique. Each one has their own permutation combination of situations that make it very unique. I strongly recommend consulting with a professional for getting professional advice on how to structure their estate plan. For creating a will properly, don't need it. You can do it on your own. But anything beyond that, if will is enough for you or something beyond that is needed, or what else can be done, is something that you may want to consult with an expert so that you have right professional advice before you take the right step.
Thank you, Nikhil, for your time and answering these questions and simplifying the whole process and giving the description of these three terminologies: trust, wills, and nomination, and helping the audience to choose the best that suits them. Thank you very much for your time, and I look forward to talking to you in one another video very, very soon. Thank you very much for your time. I remain in gratitude to you.
Absolutely. I would look forward to having more such conversations. Like I said, it's always a pleasure to be part of this show and conversation with you, Dr. Bhatt, and look forward to having future conversations. Thank you.
Dear viewers, hope the episode that I've done today helped you to understand the differences between wills, nominations, and the trust, and it would have helped you to finalize what suits you the most. If it helped you to understand these concepts, please do give me a thumbs up. If you are a person who is yet to subscribe for this channel, please do hit that subscribe button and press the bell icon. Do not forget to share these videos with your near and dear ones, friends and relatives, and on all the WhatsApp groups on which you are connected with. Thank you very much for watching this episode on NRI Money Clinic. I shall be back with you with yet another topic, with yet another expert next Tuesday. Till then, stay safe. Jai Hind.
Press the bell icon for more details and subscribe our channel.